Today we're going to be talking about intellectual property. And this is something that's important for an entrepreneur to be able to protect their business assets. And so we're going to today talk about different ways you can do that and exactly what it is that you're protecting. To start, we need to talk about what assets make up a business. And there's really two main types we're talking about: intangible assets and tangible assets. And these are very different. The intangible assets are things that you bring to the table. And here's some lists here: interpersonal skills, competition, what the competition that's out there, market presence. These are things that are part and parcel to a business, but they're very difficult to protect. You cannot count on your work quality, for example, getting you all the business. You may have a competitor that's very good as well. Today we're talking more about tangible assets. These are the things that make up your business, that have a chance you can protect them and make them your own. And these are things like the product itself. Can you protect the products so that nobody else can duplicate your product, or your process, or your name, logo, marketing material, customer list, things such as that. And that's really what we're talking about today. These are things that there are mechanisms in place for you to protect those, which brings value to your business. So today, here's the goal for today. We're going to learn what is intellectual property. What assets of your business can you protect with intellectual property? And then what type of intellectual property is available and what's appropriate for your particular business. This is actually based on constitutional law. Our founding fathers, in their wisdom, put in the Constitution a basis for protecting your rights. And this is the actual language here. The key word is exclusive. And I want to explain that because that is very important to understanding how you protect your business. And the best way to understand it is something we can all relate to, is comparing it to real estate. If you own a piece of property, you think about what rights you actually have with that property ownership. The only right you really have is the right to exclude. You can tell somebody else, get off my land. You can't build anything you want. You've got zoning requirements, building requirements, neighborhood requirements, but you do maintain the right to exclude others from trespassing on your property. And that's an important concept to remember when we talk about intellectual property, because that is very similar. With intellectual property, patents, trademarks, copyrights, you have the right to exclude others from trespassing on your property or infringing that which you own. They're a little bit different in that real estate is perpetual. Intellectual property is typically limited in duration, but they're both transferable. Just like if you ever buy a piece of property to sell a piece, you literally go to closing and you transfer money and title, and that title is then recorded in someone else's name. A patent or trademark or copyright is the same way. It is a marketable instrument, a document that describes what it is that you own. So these are the types of intellectual property we're going to talk about today. Patents, you probably heard the term, but most people don't really understand what that means. That is a title, just like a deed to land, except it's the intellectual property. But it's for a new invention or discovery. This can be for products, it can be for a process, and it protects, it's a title, gives you exclusionary rights to that product or process. Trademarks, that's really for a name or a symbol or some identifying product or service. And the idea of a trademark is it conjures up in someone's mind the product that you have for offer. And we'll see some in a few minutes. You'll see kind of what that means. Copyrights, that's really works of art. Drawings, music. And trade secrets, a totally different one. We'll talk about that later, but that's non-titled. But I'll throw that in because it's important to understand that. So in general, you have patents on a product, trademarks on a name, logo, and copyright on a work of art. Those are your three primary types of intellectual property. So now we'll talk a little bit about patents. And this is what I do for a living. I'm a patent agent. And this is my day as I do patents. I write them and I argue with the patent office every day. So what is a patent? This is a legal document, and it is actually a formal agreement between the government and the legal entity. By agreement, the reason for that is we file with the patent office a patent application. We negotiate back and forth with the office as to how far your rights extend. That's how the patent comes to be a patent, is after that process. There's a couple of requirements here. One is you have to disclose what the invention is. In other words, someone has to be able to read your patent and duplicate what it is that you're inventing. Now, this sounds kind of like not a good idea for a business, but let me tell you the backstory to this, why that's important. And again, in the wisdom of our founding fathers, it creates creativity, or fosters creativity. For example, if I develop a better mousetrap, but I don't tell you how I did that, then you have no way to try to make a better one than me. So with the patent process, I disclose it. You now know what it is that I made. You learn from it, and you try to make a better one. So that is the whole point of the patent process. And this is not just a U.S. rule. Every nation on the globe that I know of has basically the same process. In fact, the laws are very homogeneous across the globe. I don't know of any country that does not have a patent system, and all the ones I know about are very similar to ours in general. So in exchange for that, now you disclose to the world what it is that you invented. You get an exclusive right for some period of time. In the U.S. and most other countries, it's 20 years that you have that exclusive right. So here's some things that people misunderstand about patents. I told you it's an exclusive right. It's an exclusive right to stop others. It does not give you any rights in what you can do. Again, back to our property rights discussion, a patent does not allow you to make a product. It only allows you the right to exclude others from making a product that's a copy of yours. And as I mentioned, that's in exchange for that temporary right. In order to obtain a patent, there are three criteria. One is it has to be novel. Now, what that really means is that nobody else has already invented or described, taught the same thing. So basically, it has to be a new idea, something that no one else has come up with. It has to be useful. That one we really very rarely have a trouble with, because you're not going to go through the trouble of getting a patent if it's not useful. The one that's a little trickier to understand is non-obvious. What that means is one of skill in the art, which is not a well-defined term, would not find what you did obvious from what they already know. A classic example would be if you developed a washer and dryer for clothes. And you've seen this, like stacked units, but you have the top of washer or dryer, the bottom of washer, and the washer washes the same, the dryer dries the same, there's no synergism. That would not be a patentable idea because nothing has changed. That's an obvious combination of two known elements that when combined, they still function the same way they would have. So that's the criterion. We almost always, when we file a patent, examiners almost always reject it saying it's obvious, and we have to argue that it's not. So what are the benefits of a patent? Well, as we mentioned, it gives you a legal exclusionary right to your product. Again, allows you to exclude others from making that product. There's also a marketing advantage. A lot of times it's not necessarily that your product is that much better than the competition, but when you can say it's patented or patent pending, it adds just a level of credibility. So a lot of people have patents on things. Maybe it's not as a strong business idea to stop others, but it is a marketing advantage, and if they can say it's patented or patent pending, and that gives them some street credibility, and sometimes they get better fees. There are provisional patents, which a lot of people have heard about. That's basically a holding pattern. We can file a provisional patent in the patent office. It gives us 1 year to sort it out. Like if you have a new product, for example, a lot of times we file provisional patents and then take time to see if the product works, if it's worth going forward, if it has any value. And really the whole point of a patent, or any intellectual property, is to build value. And you build value through intellectual capital. If you think about the value of a business, and really any business, you mentioned intangibles, and now we're talking about the intangibles. If you want to value that business or determine the value for any purpose at all, 1 second.
You can just go back to that point. Then we'll cut it out.
Cut that off. Okay. Let's see. I forget where we.
Tangibles and intangibles.
I'll just start right here. So what are the benefits of having a patent or any intellectual property? As we mentioned, it gives you a legal exclusionary right. That gives you the right to stop others from making a copy of your product or your process. That in and of itself has a lot of value. There's also a marketing advantage. It adds a lot of credibility to a product if you can market it as patented or patent pending. That shows that there's value, that the government has confirmed the value and the fact that it is new, it is not obvious, and is useful. And therefore, that's a good marketing tool, even if the product is not necessarily that much better than the competition, but it does help with your marketing. Provisional patents is a way to get into the patent process. And I mention that because a lot of small businesses particularly want to kind of see if they have an idea, protect it. And this is a way to get a patent filed. It has a 1 year lifetime before it expires. And then that gives you a chance to try your product, try marketing it, see if it works, see if you can make it before you go for the expense of a full patent. But more importantly, it builds value for your company through what we call intellectual capital. If you think about your business, we talked about intangibles and tangibles. Well, the intangibles are hard to protect. If you want to determine the value of your company, it's hard to come up with a value for those intangibles. Sometimes the business may be because you have a great personality. You know the market. So most business valuations come down to the tangible assets, physical property, intellectual property, and usually human resources as well. So really it's a way to build the value of your company, because if you want to monetize your company in any way, most of the time what they are evaluating is your intellectual property and your real property, and then of course any human resources that come with it. So there's two main types of patents. One's a utility patent, and that's on useful apparatus or a method. It's usually the best type of protection for most products. And the reason is it doesn't have to be as specific on the design characteristics. It's more the overall function. So that is the one we seek most of the time when we're looking for a patent on a product. The other type is the design patent. This is a little bit different. This is really aesthetics. Think, for example, the Nike Air. You may have a patent on, or there might be a patent on the mechanism, the sole, the way the shoe's built. That way no one can make one that has the same features that looks different. The design patent would be a patent on the aesthetics of it. It may be nothing like the Nike Air, the way it's built, but it looks just like one. It's a knockoff. So design patents are pretty valuable for the aesthetic look. Utility patents are the functionality and the way it's built. One thing that the design patent, I use it for a lot, it's very effective, is what I call lock and key assemblies. And in that case, if you have a product you're selling, for example, and you have replaceable parts, you don't want someone else knocking off your replacement parts. Sometimes it's very valuable when you're designing a product to have particularly expendable parts that have some type of a lobe or something on there that fits into your product. And then we put a design patent on that. And that keeps someone from doing a knockoff of what is now your revenue stream going forward. You sell the product, you want to sell the parts as well. So design patents are very effective for that type of a protection. The next section is trademarks and service marks. As I mentioned earlier, a trademark really protects a name or a symbol or something of that nature. The idea is when you see that trademark, it conjures up an image of your product. An effective trademark does just that. If I say the word Coca-Cola, you know what that product means. If I say Ford, you know what that name means. That's an effective trademark because it conjures up the actual image of a product that you sell. So it identifies the source and goods. They can last forever as long as you keep using them. The difference with trademarks, well, the patents is there's federal trademarks and state trademarks. So you can get both. And here's some examples of trademarks. And most of these you've seen. I want you to think about the value of a trademark to a business. I use Coca-Cola as an example. The value of that trademark to Coca-Cola probably exceeds their marketing or their sales. That's a very valuable trademark. It's important to protect your trademark. Trademarks can have a tremendous value, and because people, again, they see it riding down the road like Pizza Hut. You're riding down the road, you may not be able to read that logo, but you know what it is. You know it's a Pizza Hut around the corner. So trademarks are very valuable. One thing that I always suggest when it's possible is when you're developing a trademark name for your company or your product, is to try to also do it in concert with developing your URL. It's very valuable to have a trademark name and a matching URL. The reason is it makes it easier to find your company or your product. So that's a very valuable exercise when you can do that, is to make sure that they match. That way you don't have somebody trying to find your company and your website name is totally different. Like copyrights. Copyrights are for works of art. Music, paintings, photography, any type of text writings. So they protect the authorship in a tangible medium. Now, a copyright is effective the minute you put pen to paper. So you can get a formal trademark, a copyright through the patent office, or you don't have to. You can just mark it as copyrighted, and that marks it as yours. So there is no requirement that you file for copyright protection, but it is highly recommended, because if you do not, then you're limited in what you can do to stop somebody else. But again, it's an exclusive right to reproduce it, perform it, sell it, display it, and that's what the copyright protection does for you, is it gives you those rights. As I mentioned, it becomes a copyright when you put pen to paper, or in this day and age, some other readable medium, some tangible form. It lasts for the life of the author plus 70 years. That was changed recently because of the Sonny Bono Act. I think Disney has something to do with that as well. It's important to register it because, as I mentioned, if you don't, you lose your statutory rights. Now, one thing's interesting with copyrights is there's what's called statutory damages, which means if someone copies your material, say it's a song, you can actually get money for each instance of them performing that song. Or if they steal your painting, each instance of them copying your painting, you can get damages for it. So copyright damages can add up in a hurry. But you have to have it registered with the Copyright Office before you can actually exercise those rights. Now, trade secrets is this was different. I want to explain it because, as we mentioned, patents are a title to a piece of property. Trademarks are a title to a piece of property. Copyrights are a title to a piece of property. Trademarks are just the opposite. Trademarks are not titled. They are kept secret, obviously. The things that are trade secrets that you may not think about in a business are things like your knowledge, your experience. Those are things that you want to protect. It's a trick when you have employees, for example. How much of your business do you describe to them? How much of your business do you want your employees to know? And at what point do you risk them going out and competing with you? Sourcing information. If you have a product you're manufacturing, where you get your raw materials, it could be a very valuable piece of information. That's something you might want to protect. Client list. You don't want someone necessarily knowing who all your clients are. Your fees, fee schedules, relationships you have. Those are things that are very valuable to a business, and yet they're not titled on purpose because you don't want to disclose it to title it. So these are things you have to keep secret, and they must be protected. An example of that is most manufacturing facilities you go to have some form of a gatehouse or locked lobby or something. You can't just go wander into a manufacturing plant. Part of that's safety, but part of it's trade secrets. They don't want people wandering through because they could learn how it is that the plant operates, and that would not be good for the company. So here's an example of a copyrighted statement. I copyrighted it this morning. This is the entrepreneur's motto. It's from Joe, and that is, don't let success fool you. Once you get successful in a business, sometimes you get a little complacent, and don't let failure deter you. Keep at it. Thank you. If you have any questions, your teacher, Ben Kishier, can put you in touch with me, or you can give me a call, and I'll be glad to talk with you. Thank you. Boy, I feel like I flew through that.
No, it's actually